The short answer is yes. The debtor can appeal either to the federal district court or to the bankruptcy appellate panel for the Ninth Circuit. And there are strategic issues there, which is better. The default, if you file a notice of appeal with the bankruptcy court, is that you're going to go to the bankruptcy appellate panel. If the creditor or the plaintiff in the underlying adversary proceeding doesn't want to go to the bankruptcy appellate panel, the creditor, generally it's the creditor, can file a notice that it wants to go to the federal district court. Once that's established, that's the end of the road. You don't get to hopscotch back and forth. So what are the benefits, pros and cons of going to the district court as opposed to the bankruptcy appellate panel? The bankruptcy appellate panel is comprised of bankruptcy judges throughout the Ninth Circuit. The one restriction is they cannot sit on a panel that is considering a case from their district, but they can sit on a panel considering cases from some other district. What's at work there? Well, since you're dealing with bankruptcy judges, these three judges know the ins and outs of bankruptcy. If you're a bankruptcy judge, you're really conversant on the subtleties there. So if you have something that you really feel you should win on that requires some detailed knowledge of bankruptcy, you might want to be in the bankruptcy appellate panel. By the way, that's sometimes referred to as the BAP, because bankruptcy appellate panel is a lot of syllables, so we just say BAP or BAP. On the other hand, federal district court judges don't have specialized knowledge in bankruptcy. They cover a wide panoply of cases, criminal cases, civil cases of all sorts, and they might not have very many bankruptcy appeals because they're dealing with all kinds of stuff. This is not to say that they aren't intelligent. They're highly intelligent, but they don't have that specialized knowledge that a bankruptcy judge would have. So if you feel that what you've got doesn't require specialized knowledge of bankruptcy, or maybe take it one step further, you think specialized knowledge in bankruptcy might prejudice the trier of fact against you, well, in this case, the appellate court against you, then you might want to go to the federal district court. Anyway, there are pros and cons. One con, however, to going to the district court is they tend to move at a glacial pace. The bankruptcy appellate panel, or the BAP, moves pretty quickly. I've had cases before the BAP, and they get resolved just in a matter of a few months. I've had actions going on in the federal district court that go on quite literally for years because the docket for a federal district court judge is very large. And I suspect that they're not particularly enamored of bankruptcy appeals, so that tends not to move very quickly. In any event, the long and short of the answer to the question is yes, the debtor can appeal.